All right, I'm going to call this morning's docket. When I call your name, please say present or here and raise your hand. Michelle Daly. Jennifer Gathright. Jennifer Lee Gathright. Kelly Gathright. Do we have the waivers on those? We do have waivers. They've been filed. What's the pretrial? Do I have your docket? Yeah, I think the dockets got switched. I've got the probation docket. That's gonna help a lot of people. Yeah. This might be mine. Knew it didn't look right. All right, so Mr. and Miss Gathright, represented by Heath Hyde, waivers of arraignments have been filed. You, Ms. Tabram, do you know when we set that? Okay, just so we can tell the state. Audrey Thompson. Audrey Jean Thompson. Ashley Olds. Damon Jackson. Thank you, Mr. Forey. Glenn Smith. Tracy McGahee. Thank you, Mr. Kimball. Brandy Rhodes. Thank you, Ms. Beasley. Megan Bailey.
Judge, I've been in touch with her this morning. She was one. She told me it's a sick child, but also she's got fever, sore throat. So I told her.
Okay, we'll recall that. Landon Musgrave.
And just I also heard from him. I'm over 2 right now. He will be here. He's on the way.
You want to go ahead and announce on your next one? Oh, good. Sarah Potter. Janice Espino. Hipolita Grijalva. Caleb Richardson. Caleb Reed Richardson.
Oh, no, he's in the hospital. He was in a car accident, I believe, with his parents, telling everyone, with no information one way.
Okay. Marcus Gardner.
This morning.
Tony Curtis. Okay. Wendy Jones. I felt like the courtroom was rather light when I walked in on a 50 case docket. Joseph Couch. Joseph Brian Couch. Ethan Evans. Gold star from Mr. Evans and Mr. White. We broke the drought there. Christopher Hunley. Thank you, Mr. White. Melanie McQuarrie. Did you raise your, okay. Thank you, thank you. Is there anyone else who's in the courtroom whose name I've not called? Yes, ma'am, your name? Butler? Lakeitha? Deidre? Do you have an attorney, Ms. Butler? And are you here for criminal court today? What are you here for? You probably need to be downstairs on the second floor in Judge Winter's court. You're welcome to stay up here, but you're not gonna. Yeah, just go down the stairs and go to the middle of the second floor and Judge Winter's court is down there. You're welcome. All right, counsel, we have anyone that's ready? Ms. Beasley? Ms. Rhodes? Yes, ma'am. All right, Ms. McGay, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. Ms. McGahey, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And in this case, you're represented by your attorney, Mr. Brent Gimble. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all your legal questions answered? Anything about the paperwork that you've read and signed today that you do not understand? Mr. Gimble, do you believe your client to be competent today?
I believe she is.
And you've explained to her her legal and constitutional rights?
Yes, I have.
Ms. McGahey, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams. The range of punishment for a first-degree felony is confinement in the Texas Department of Criminal Justice for not less than 5 years or more than 99 years or life, and an optional fine not to exceed $10,000. You understand that full range of punishment? Now, it looks like there's a plea agreement in this case that you're going to, in exchange for your plea of guilty to that charge, the state's recommending that your punishment be set at 10 years confinement in TDC, with that being suspended and you being placed on community supervision for 8 years, you paying a $4,000 fine and restitution of $180 plus reimbursement fees for your attorney fee and other fees at $1,285 and also paying court costs at $290. Is that your understanding of the plea agreement? And that's what you want the court to approve today? All right, Ms. McGahey, then how do you plead to that offense? And are you pleading guilty because you are guilty of committing that offense? I'm sorry, and you're gonna have to let me finish before you answer, because my court reporter here, she can't take down what we're both saying. Hang on, you're still doing it. You got to wait. Let me finish. Do you understand? You have to say, and then you have to say yes or no out loud. Okay. Okay. Ms. McGahey, has anyone threatened, forced, or pressured you to plead guilty? All right, court will accept Ms. McGahey's plea of guilt at this time. Mr. Gimble, any objection to states 1?
No objection, no.
All right, states 1, stipulation of evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No,
From the defense?
no, Your Honor.
Mr. Gimble, is there a lab report for this charge? I don't see it included in the stipulation.
There is, Your Honor. I mean, that's-
If you can print that out for me, I'd appreciate it. Do you want Mr. Gimbel to just submit his copy?
If Mr. Gamble is comfortable with that.
All right, I'm just gonna go ahead and mark this as State's Exhibit 2. Any objection to State's Exhibit 2, Mr. Gimbel?
No objection, Your Honor.
All right, State's Exhibit 2 is admitted into evidence.
Review that just to make sure it's the same copy. Yeah.
Okay.
That's fine.
All right, Ms. McGahee, based on the evidence, I do find that there is enough evidence to convict you of this offense. The court will follow the plea agreement in this case. Court hereby convicts you of the first-degree felony offense of manufacture or delivery of a controlled substance of penalty group 1, greater than or equal to 4 grams, less than 200 grams. The court assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice. Court suspends that sentence, places you on community supervision for 8 years. Court orders you to pay a $4,000 fine, $180 restitution, reimbursement fees of $1,285, and court costs of $290. So Ms. McGahee, you understand that once you're on probation, if you violate any term of your probation, if you test positive, if you drink alcohol, if you don't do your community service, if you decide you're not going to report, state can file a motion, they can bring you back before the court. And the issue at that time is not whether or not you possessed controlled substances, but rather, did you violate your community supervision? The court at that time finds, based on the evidence that you did, court could revoke your community supervision and sentence you to 10 years in prison. You understand that? All right, let this be the last time that we're having to meet like this. All right? So I'm gonna do my end of the job. And you need to do yours. And I don't want any whining and crying if you don't do your end of the job. You understand? All right, Ms. McGahee, you are hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted by the bailiff. After that time, I'm gonna have you step over with Ms. Burns and they'll give you more information about your probation. So you can step on forward there. Thanks, sir.
Thank you.
How in the world did you get out with just one case today? I must not be doing a very good job. Yeah. Do you have anything this afternoon? No? Well, enjoy your day. We have any other counsel that's ready? No? Are you ready? Is your client here? I believe I called earlier and was not here.
Called me yesterday. I told him to be here today. Better ever hear.
I'm not sure I see on my docket who you're referring to.
He's not, he was last week, he was broke last week, told him to be here today. Apparently he's coming today, has to sit in the hall. I will attempt to contact the bondman on this account, since he had a very reasonable pre-offer. Advice, I guess. New sentence.
Mr. Sanders, do you have any clients that are here and ready?
I think they're here now, but we're not ready twice.
Okay. Who is here for you, Mr. Sanders?
Landon, Musgrave, and then Sarah.
She did last month. That's why I touched last month, stopped it to that. She did that food service and then I think she paid. She was like, told her. He was holding it.
It's not on your docket today. This gentleman is in jail. He has multiple issues elsewhere. We're hoping will resolve our case as well.
It's not, so this is a drug case. Okay. All right, Ms. Daly. So the probation department has reported to me that you paid, but you didn't do your community service. Is that right?
I tried to fax it to her Friday, but the fax machine at the bank was down, so I faxed it to her yesterday. And I know it was not in time. But that was my fault, Parker, but I did complete my hours.
So how many hours did you work?
I have 10.5.
10 and a half? And when did you finish that by?
I finished it by Thursday.
And have you talked to your probation officer this morning?
Yes, I talked to her yesterday, and she told me if I have a two-hour before noon yesterday, that I would get credit, but she couldn't verify my hours until the point because the place that I'm doing it was closed yesterday. So like I told her, I would explain to you, it's not her fault. But my hours were complete. I just didn't have it turned in on time.
Where'd you do your community service at?
In Longview, Texas.
All right, Mr. Daly, what we're gonna do here is I'm gonna reset you until August 24th. We're gonna do the same thing. You're gonna make your payments. I've written them down on here. You're gonna do your same 10 hours that's required or more, minimum 10 hours. And because you didn't meet your deadline and we couldn't verify your community service, you're gonna write me a 2-page paper on the importance of meeting deadlines. That's a requirement. If you don't do that, that's the same as not paying, not reporting, not doing your community service. You know, I've got it written on here. All right, once you get the yellow copy, check in with probation, see if they need anything else. And then after that, you'll be free to go. Melanie McQuarrie. Good morning, Ms. Johnson. How are you? All right, this is cause number CR 2347, State versus Melanie Renee McQuarrie. Ms. McQuarrie, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Make sure you speak up loudly and clearly, okay? Ms. McQuarrie, are you a United States citizen? Do you read, write, and speak English? Ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Paul Johnson. Are you pleased with his representation of you? Yes. Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about the paperwork that you've read and signed that you do not understand? Mr. Johnson, do you believe your client to be competent today? And you've explained to her the advantages and disadvantages of a deferred adjudication plea? Ms. McQuarrie, you're charged by indictment with a 3rd-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. A 3rd-degree felony carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. You understand that range of punishment? If I were to approve this plea agreement today and place you on deferred community supervision, If later during the term of your community supervision, if you violate any of the terms, the state could bring you back on a motion, and if the state proves that to the court could revoke your community supervision and assess your punishment all the way up to 10 years in prison. You understand that? And understanding the full range of punishment and the plea agreement being a recommendation of deferred for 3 years, along with a $2,000 fine, court costs, and restitution, and another case, another possession case being dismissed. Understanding the plea agreement and the range of punishment, you still want to go forward? All right, Ms. McQuarrie, then how do you plead to that charge? Guilty or not guilty? Are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty? All right, court will accept the defendant's plea of guilt. Mr. Johnson, any objection to states one stipulation of evidence? All right, stipulation of evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, the court has reviewed the evidence, and I do find there's sufficient evidence to convict the defendant of this offense. However, the court will follow the plea agreement. Court hereby defers the finding of guilt, places the defendant on 3 years community supervision, assesses a $2,000 fine, orders her to pay $290 court costs, $180 restitution, $85 reimbursement fee. Court also takes into consideration under section 1245, DA 2023-44, possession of controlled substance, penalty group 1 less than 1 gram. Ms. McQuarrie, have you ever been on probation before? You have? Was it for a misdemeanor or a felony? DWI? And did you successfully complete that, or did you get revoked? So you know that being on probation is not an easy task. And you also, having been on probation, understand the importance of complying with all of the court's orders. And you do understand, because I told you what could happen to you if you violate. State, I don't have a lab report in this case either. So I'm gonna have them print out the lab report, and they're gonna offer it at State's Exhibit 2. Will there be any objection to State's Exhibit 2? We'll make sure you get to see that before. All right, state has offered State's Exhibit 2, the Department of Public Safety Laboratory report. Any objection, Mr. Johnson? And this has been provided to you in discovery, and you've seen it today, correct? All right, State's Exhibit 2 is admitted into evidence. Mr. Query, based on the court's review of the evidence, I do find that there's sufficient evidence to convict you of this offense. However, the court will follow the plea agreement in this case. Court hereby defers the finding of guilt, places you on deferred community supervision for 3 years, orders you to pay a $2,000 fine, $290 court cost, $180 restitution, $85 reimbursement fee. Court does take into consideration under section 1245 DA 2023-44. Mr. Query, you're hereby remanded to the custody of the Van Zandt County Community and Supervision Corrections Department so that they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted by the deputy. After that, I want you to step over here to my right, your left, with Ms. Burns, and they'll give you more information about your community supervision. Mr. Query, you can come on around or step through, it doesn't matter. You're very welcome. No, it should be the second page of the judgment. There's no square. Yeah, right there. We have any other counsel that's ready? Mr. Flory, are you ready?
Yes, sir. Mr. Smith, Jackson, each
Damon Jackson, CR 2122, CR 21173. Just go to the middle podium there, Mr. Jackson. Mr. Jackson set for pretrial today.
Yes, sir. And we've made some progress. Resolution, not quite detailed yet.
You're welcome. Are there any contested pretrial motions filed? There being no contested pretrial motions, court sets Mr. Jackson for docket call. Are you available on August 24th?
That week,
Next date after August 24th would be September 14th. State. All right, Mr. Jackson, the court's going to set you for docket call on September 14th at 9 a.m. And on that date, the court will be expecting to hear if there's a resolution or a request for a trial. Mr. Jackson, once you sign the yellow copy, you're free to go. Do we have pretrial on there? Do we have? I know we just. Hmm. Oh, she is. I've got her on.
So
A,
she's Rachel's.
I've got her on arraignment.
I'll go double check.
Glenn Smith. 2025-92, also set for pretrial. Mr. Forey, any contested pretrial motions?
No, sir, family house.
All right, this is also CR 2192 as well. All right, court will set Mr. Smith also for docket call on September 14th at 9 a.m. Mr. Smith, once you sign the yellow copy, or once you sign and get the yellow copy, you're free to go. You're welcome. Yes, sir. And for the record, CR 21-117, CR 21-118, Jennifer Gathright and Kelly Gathright. Court had indicated earlier that Mr. Heath Hyde has filed a notice of appearance, a letter of rep, and has also filed a waiver of arraignment. And court approves that waiver and sets each for pretrial on September 14th. The Gathrights.
Thank you.
Mr. Sanders, are you ready on anyone?
Yes.
Who do you want to call first?
Landon, that's great.
CR 2087. Show Mr. Musgrave to be set for an open plea today. Is that right?
That is correct.
Are we doing the open plea today or?
Oh, no, we were. just moving through
All right, Mr. Musgrave, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Put your hand down. Mr. Musgrave, I hold in my hand a document that you signed along with your attorney and the attorney for the state called waiver of jury trial. Have you read this document? Do you understand what it says? You understand that by signing and submitting this document, you're telling the court that you understand that you have a right to a jury trial, that you have the right to confront the state's witnesses and their evidence in front of a jury, but that you also have the right that you can waive that right. You understand that once you waive it, there's very limited circumstances in which it can be restored to you. It's not, I've changed my mind and now I want a jury trial if you don't end up working the case out the way that you want it, or, you know, the court doesn't accept a plea agreement. You understand that? Understanding those things, you still want to go forward and waive your right to a jury trial? All right. Court finds that Mr. Sanders and the attorney for the state, Ms. Heisel, have signed and joined Mr. Musgrave in this request to waive jury trial. Court finds that it has been entered into intentionally, knowingly, and voluntarily, and approves the waiver. All right, Mr. Sanders, do we just need to schedule the case then for the open plea?
Yes, and if we could set up a couple months. He has a new case that I think just recently got decided that we need to try to get everything done. And there's a couple other matters about the state out. In September, that might be something that said if we did that, we would have everything.
And does Mr. Musgrave need, is this going to be a true open plea, or is this just a waiver of jury trial on our way? Is this a slow plea or is this an open plea? The reason I ask is because I need to inform the probation department whether or not they need to do a PSI.
Judge, at this point, I believe Mr. Musgrave is rejecting the state's offer. He wants no complete. However, the additional information that I'm following up on has changed that. I don't have very much hope that that would change the circumstances. So I don't know how to answer that at this point, other than I believe we're kind of still as a state. Without information.
And Judge, I think we could get a PSI.
I was going to ask you, do you want a PSI or do you want the court just to rely on the evidence that's offered at the time of the open plea? Testimony and any offense reports or anything that's being offered?
Judge, we can go ahead and do it. Yes,
Okay. All right, let's look at, are you available? You said end of September. Are you available September 28th?
Yes.
All right, court sets Mr. Musgrave for open plea before the court on September 28th at 9 a.m. Do we believe that the remainder of his cases will be ripe at that time for disposition?
Yes.
We intend to wrap everything up.
Okay, so are there cases that need to be indicted, or are these just cases that are going to be considered?
Judge, it has already been decided, has not been set for arraignment yet. But by that point, we expect to share all the discovery. We can't reach an agreement, this division of the board, depending on what it is, we might be resolved.
On that day?
Yes.
Okay. All right, Mr. Musgrave. We'll see you back on September 28th. Once you sign the yellow copy, you're free to go. Sarah Potter, CR 21-138. Ms. Potter set for pretrial today. Any contested pretrial?
No. Retrial issue. It's asked for the accept the document.
Are you coming back in August?
So if it's possible, early September, the reason why she has a CPS case that's pending, and she's about 6 months into that. And I think from talking with the state, kind of how that goes to kind of affect what we do here in criminal court. So if it's possible to do it a little bit later. CPS takes that.
September 14th.
Yes, that's great.
All right, Ms. Potter, court sets you for docket call on September 14th at 9 a.m. Once you sign and get the yellow copy, you're free to go. All right, CR 2378, Megan Nicole Bailey set for plea today. Mr. Sanders, you said that she is home sick. Can she appear via Zoom?
Well, that's what I was gonna ask. We can do that because I texted her. Yes, she can do that. So if that's possible, then that'd be great.
Yes, if you want to step out and speak with Ms. Abraham, she can get you the Zoom ID number if you don't already have it. And we'll call her that way.
Okay. All right.
Warner, you ready? Mr. Curtis? CR 2157, Mr. Curtis set for pretrial.
He is judge. I've spoken with the state. As part of the discovery, just the videos were shared, so not the paper discovery. They have since shared that with me. This is our first pretrial setting. I asked for a second pretrial setting. The information is shared. Judge, there was a. We're not opposed to.
Do you know when you're coming back in August, if you are?
I am August 12th.
Okay,
Let's be a busy morning.
let's do that.
Okay.
Mr. Curtis, court's going to set you for an additional pretrial on August 12th at 9 a.m. Once you sign and get a copy, you're free to go. Make sure that you're in court at 9 a.m. next time. Don't leave Mr. Weiner hanging here trying to defend you. It's hard for him to defend you when you're not here to defend yourself.
I'll need a picture of that.
Miss Jones make an appearance. Okay. Who's her bondsman? East Texas bail bonds?
You know, I'm not sure.
I show one to be East Texas bail bonds and then one to be Easy Pickens bail bonds.
This is the COVID side case that I have the documentation, anything where I can say or. So, let me see if I have all.
Has she been in contact with your office at all?
I have been in contact with her. But I'm surprised she's not here. Based on that,
So you expected her to be here.
I did. Yeah, I don't think I had any.
It's okay. I'm gonna look it up here. That's just what my docket's showing. Doesn't mean it's correct. Computer's been real sluggish.
Like
Everything, just like me. All right, I can't access her bond information. I can't even access the case right now, so. Court will,
Get the physical copy.
no, that's okay. I'll have her name called later. And I guess if she makes an appearance before the morning docket concludes, then I'll hear her out. But otherwise, if she doesn't appear, then the court's gonna issue a judgment not side alias capious.
I understand that.
25,000. What about her other case? CR 13,368. She's definitely on bond. Otherwise, it'd be this afternoon. I'll say it was like a, 6-6. But we withdrew one. We may have withdrawn that one. That's okay. I'll figure it out. I'm not going to keep you here, so.
That's all I have, Judge. Can I please see you?
Yes, sir.
It's good seeing you.
Good to see you. Mr. Russell, are you ready? Is Mr. Gardner here, Marcus Gardner.
Your Honor, when last he was in court, still thought he was. I called him and
Okay, we'll wait for him. Mr. White, are you ready?
I don't think it's.
Okay, you're just waiting on paperwork? Is that Mr. Grijalva?
Yes.
Mr. Grijalva, if you'll come forward, sir. This is cause number CR 1851 and CR 18398. Mr. Grijalva, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Grijalva, just make sure you speak up as loudly and as clearly as possible so my court reporter can take down everything that you say, okay? Okay. Your name is Hipólito Martinez Grijalva, is that right? And Mr. Grijalva, are you a United States citizen? Sir? You're a lawful permanent resident, but not a citizen. And have you discussed the case with your attorney regarding potential immigration consequences that would affect your legal status within this country? Mr. White, have you had those conversations with Mr. Grijalva?
Yes, Your Honor, I always advise all my clients that they should wind up speaking to an immigration lawyer on that. But we are ready to proceed under these circumstances.
Okay. Mr. Grijalva, have you ever been diagnosed with any type of mental condition? No?
Yes, sir.
What have you been diagnosed with?
Moral failure.
What about mental, like depression or schizophrenia or bipolar?
I believe he said early onset Alzheimer's. I was not aware of that.
Are you aware of any mental health diagnosis?
I am not.
Mr. Grijalva, are you on any type of medication or seeing a doctor for any mental conditions at this time? You are? What kind of medications are you on?
Your Honor, we have given a list to the probation department with that. He recently had a concussion. With some medications.
Mr. White, do you believe Mr. Grijalva to be competent today? And during your course of representation of him, have you had any concerns that he's not been competent at any point or that he doesn't have a rational understanding of the proceedings against him?
No, I believe he understands.
And Mr. Grijalva, are you pleased with Mr. White's representation of you in this case? Are you pleased with him being your attorney? Do you feel like you've had enough time to talk with him about your case and have all your questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
So, Mr. Grijalva, I see here that you've been charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's a second-degree felony that carries a range of punishment of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that full range of punishment? Do you understand that if the court approves the plea agreement today and places you on deferred community supervision, if you get on community supervision or probation, if you violate the terms of your probation, then you can be brought back to court. And if the court finds that you violated, the court could sentence you, could revoke your probation, your community supervision, and could assess your punishment all the way up to 20 years in prison. Do you understand that? Okay. And understanding that, you want to go forward with the plea agreement today? Okay. So, Mr. Grijalva, let me ask you, how do you plead to that offense? Guilty or not guilty? And are you pleading guilty because you are guilty of committing that offense? Are you guilty? Are you guilty? Are you pleading guilty because you are guilty of doing what they said you did?
Yes.
Okay. Court will accept the defendant's plea of guilt. Mr. Whiting, any objection to states one?
No objection.
All right, states one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
I would like to point out to the court that we have already turned over numerous medical records in relationship to this case. He does have some medical problems. And one reason why this case is famous, that he may have to have some type of consideration.
Okay, and that's been submitted to the probation department or the state? Okay.
To the probation department.
All right, court's reviewed the evidence and I find there is sufficient evidence to convict the defendant. However, the court will follow the plea agreement and the recommendation made by the state. Court hereby defers a finding of guilt for the second-degree felony offense of aggravated assault with a deadly weapon. Court places Mr. Grijalva on 10 years community supervision, assesses a $2,500 fine, $290 court cost, Orders him to pay $90 reimbursement fees. Mr. White, can you have your client sign this one right here? That's this certificate of discovery. Sir. All right, Mr. Grijalva, you hereby remanded to the custody of the Van Zant County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. You understand that you can't be drinking alcohol while you're on probation. Alcohol equals prison. You understand? Any bit, none, zero. Alcohol equals prison. You remember that. All right, I want you to come forward. I'm gonna have you fingerprinted. You may. Do we have? Is there a 1245? No, there's two cases.
There should be, if it hasn't been turned over to the court, we'll look into that, make sure it is.
Just don't remember seeing it on there. I could have overlooked it. Though. What does it say on the judgment right there?
It's supposed to be 12.5. It is, I just don't know if it requires. It does not say, Judge, we will,
The DWI?
the DWI, we're taking into consideration dismissing.
Okay.
Judge, did you hear that? Yes. For the record, we are taking into consideration dismissing the DWI.
Does the conditions of probation take into consideration the DWIs or interlock or anything of
I
that
don't
nature?
believe so, Judge.
Is that, and that's not stemming from the same
No,
incident?
no, Judge, there are separate incidents.
Court would want a condition, Ms. Burns. Court would want a condition that he have an interlock on his device. If I'm taking into consideration the DWI, I'd want at least an interlock on there.
State is absolutely important.
So I'd like to add an interlock to the conditions of community supervision. He has a DWI and an ag assault. They're 1245 and we 1245 or going to 1245ing the DWI. Since we're taking into consideration, I'd like to have an interlock on them. So the DWI third one.
Okay, on this guy?
Yeah, on Mr. Grijalva.
Who is it? We'll call it right now.
Spano has 3 cases.
Espino, Jan Espino, CR 21. Come on up to the middle podium. 113 and 114. All right, we're set for pretrial today. Yeah, it's not, yeah, it wasn't right there. 115.
Your Honor, this is set pre-trial. I've already filed normal state motions that I normally do on the course of any case, and I have no opposition to it. But I am going to be asking the court to allow me some more time to have pre-trial. We have some discovery that I haven't received yet. I don't know what they're called, the computer sticks. And there's quite extensive discovery on it. I've got 17 people. And in consideration of when we replace that or reset this, I am number 1 on a 25 to 9 days downstairs at the end of August. But I had that chance, obviously. Right.
Okay. Any objection from the state, request for additional pretrial setting?
No, Your Honor, there is full.
All right, the court's going to set Mr. Espino for pretrial on September 14th.
That sounds great.
Once you sign the notice of setting and get the yellow copy, you're free to go. Mr. Gardner. All right, this is cause number CR 2161-162, State versus Marcus Gardner. We're set for a docket call today. Court will note for the record that Mr. Joseph Russell did file a motion to substitute counsel. The court reviewed that prior to today's hearing, granted that motion to substitute, has relieved the Honorable Justin Weiner as counsel for Mr. Gardner. We are set for docket call today. Have you had any chance to speak with the state to get up to speed?
I have spoken to the state, Your Honor. Obviously, I have not had a chance to go through any discovery in the process of getting that and making sure I'm signed up on the court. Stephanie's supposed to be sending me an email. So I can get set for another docket call. The 14th, I'm set for jury trial on inmate in Kaufman on the 3rd. I have every expectation that I'll be going on that. So the 14th would be kind of an issue for me.
You said in August or September? In September. What about August 24th? Gives you a little under 30 days. Next date after September 14th would be September 28th.
That would be great.
All right, court will set Mr. Gardner then for September 28th for docket call. All right, Mr. Gardner, make sure that you show up in court when you're supposed to. Otherwise, I may be in a position to have to just find your bail to be insufficient and put you back in custody. So Mr. Russell was here and told me that you were on your way. So I gave you a little bit of latitude, but I don't want that to become a usual occurrence, okay? Once you sign this notice of setting and get the yellow copy, you'll be free to go. Mr. Sanders, are you ready on Miss Bailey? I see that she is logged in. Oh, so there was a 12:45. Okay, I guess I just missed it. I did, yeah, I just missed that.
And that's an amendment to that.
Okay.
Thank Jeff.
Yes, thank you, Mr. Russell.
Yes, sir. We
Oh,
can see.
It's a good looking jacket you got there.
I saw Jeff left, and he's just looking at me like I'm crazy on that now. You only have to talk. So you're not-
Who's looking? Who's?
This guy?
Yeah, sure. Is Jeff White still here? Is Jeff White still here?
I haven't seen him. I think he left.
Okay, he
I'll
was,
check the hall.
check the hallways. I mean, he maybe just. All right, Mr. Sanders, if you'll step on up. All right, good morning, Miss Bailey. I'm going to ask you to unmute your device. If you'll just click. There you go. Can you see and hear me okay?
Yes, sir.
All right, Miss Bailey, we are in open court. This is cause number CR 2378. And Mr. Sanders is here. If you can't see him, you have to move left or right on your, if you're on your phone, you may have to swipe left or right to see more participants, but he's present here. Mr. Sanders has indicated to the court that you were unable to be here today due to illness. Is that correct?
Yes, sir.
Okay. Do you believe that you may have COVID, or are you experiencing any type of COVID-like symptoms?
My throat is hurting really bad, and I was running a fever. My 2-year-old's running a fever, throwing up. She's been coughing. I've had a little bit of mucus coming up, but I don't have very much respiratory problems. It's just my throat is really hurting.
Okay. All right. And we were set to enter a plea today. Is that right?
That is
And what was going to be the terms of the plea?
correct. 3-year deferred adjudication probation.
Okay. All right. So how long have you been feeling ill, Miss Bailey?
This just happened overnight.
Okay. All right. Today is the 27th. I'm going to bring you back. Are you available August 10th or 12th? Are you here on either one of those days? Are you out?
I think 12 would be fine.
Think so?
Yes.
Okay. So Miss Bailey, what I'm gonna do is just order you to be in court on August 12th at 9 a.m. So that'll
Yes,
give you a couple of weeks, and hopefully you'll feel better by that time. So this will be the only notice I give you since you're not in court. You understand?
Yes, sir. Thank you.
All right. We'll see you back on August 12th at 9 a.m.
Thank you.
We ended up working with the court too. Part of the reason we had reset the plea was because of, she was trying to check into how this could affect her housing situation. And so, and by doing this, it's not giving you some more time where I can check. Well, I think there's still some issues. And so hopefully we can get all that ironed out by the 12th.
Okay. All right. Thank you, Miss Bailey. We'll see you back on August 12th.
Thank you, sir.
You're welcome. Mr. Sanders, is that all you have?
Yes, it is.
Ethan Evans? All right, Mr. Evans, if you'll raise your right hand, sir. Mr. Evans, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. Mr. Evans, are you a United States citizen? Do you read, write, and speak English? Ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Feel like you've had enough time to discuss your cases with him, have all your questions answered? Mr. Evans, anything about the paperwork that you've read and signed today with Mr. White's assistance that you do not understand? I see that you have two charges. One charge of possession of controlled substance, another charge driving while intoxicated. Second, actually, no, not a second, a first. The plea agreement appears to be that you're going to plead guilty. Ma'am, I understand you're upset, but I need you to be a little bit, I can't hear what's going on, okay? So if you'll whisper for me, I appreciate it. I see the plea agreement is that you'll plead guilty to the driving while intoxicated in exchange for the state's recommendation that your other case be dismissed and you be placed on community supervision, deferred for 12 months with paying fines and court costs and reimbursement fees. Is that your understanding of the plea agreement? Now, Mr. Evans, a Class B misdemeanor offense of driving while intoxicated carries a range of punishment of confinement in the Van Zandt County Jail for no more than 6 months and a fine no more than $2,000. Do you understand that range of punishment? That means if I approve this plea agreement and I place you on community supervision for a year, if you violate any of the terms of your community supervision within that year, the state could file a motion, and if they prove to the court that you violated, I could revoke your community supervision, convict you, and place you in the Van Zandt County Jail for up to 180 days. Understanding that, do you still want to go forward with the plea agreement today? All right, so Mr. Evans, understanding the plea agreement and the range of punishment, how do you plead to driving while intoxicated? And do you plead guilty to that charge because you are guilty of committing that offense? Mr. Evans, has anyone threatened, forced, or pressured you to plead guilty to that offense today? All right, court accepts the defendant's plea of guilt. Mr. White, any objection to state's one?
No objection, Your Honor. One of the things that I believe the judgment, maybe I think a mistake, put down the fine is supposed to be 1,500 is I think we made it to 2,500.
Is that the agreement for a fine of 1,500? Oh, that's true. Okay, so you mean,
Yeah, I didn't realize that I saw it. I mean, I think it's actually supposed to be 1,400.
okay, I'll tell you what, let me give you the written plea admonishments. If you'll take that to Mr. Evans, and if all of you and Mr. Woodbine, Mr. Evans will just initial that, I will fix it here on the judgment. Is there a bill of cost that Mr. Evans has that needs to be fixed as well? Yeah, we'll need to take that to the clerk and get that. Just so that when he goes into collections at all, that it'll be accurate. Okay. No problem. I'm glad you caught it now. Catch it now better than a nut croissant later, right? Did I admit State's Exhibit 1? Have I offered that? Had they offered that?
They offered it. So as it is now, the state offered it.
All right. Okay. So State's Exhibit 1 is admitted into evidence. The court does take judicial notice of the defendant's judicial confession. I'm just going to review the discovery until Mr. Woodwhite gets back with that bill of costs. All right, Mr. Woodwhite, were the clerks able to provide a new bill of cost for Mr. Evans?
Yes, Your Honor, and correction, the fine will be $1,400 with. and
Thank you.
total fine of
Thank you for handling that. All right, Mr. Evans, I have reviewed the evidence and I do find that there's sufficient evidence to convict you of driving while intoxicated. Court does convict you this date of that offense, Class B misdemeanor. The court the court does not convict you. It finds that there's sufficient evidence to convict you. However, the court will follow the plea agreement, will place you on deferred community supervision for a period of 12 months. Court orders you to pay a $1,500 fine, $270 court cost, a $15 reimbursement fee. Court takes into consideration with this plea agreement under section 1245, cause number CR 2117, in which you are charged with possession of a controlled substance in penalty group 2, less than 1 gram. So Mr. Evans, you ever been on probation before? First time? So it just so happens that this time that you get to take the benefit that many that have gone before you do not. And that means you have a chance to keep this off of your permanent record because you can take advantage of a deferred plea, whereas in years past, DWIs did not have deferred pleas. So that means you've been given a very good opportunity. Mr. White secured a very good plea agreement for you. So now the ball is going to be in your court and you can go into this community supervision and not take it serious. And you can find yourself back in here and you can find yourself back in the Van Zandt County Jail for up to 6 months. And you can find yourself with a conviction on your record for DWI. And the next one becomes a higher one. The next one becomes a felony. So how old are you? 22. I mean, you just started, last year is the first time you could legally drink and you already find yourself in trouble with the law due to drinking. So I hope that this is a wake-up call for you. If you're going to drink, I want you to be responsible. Don't get behind the wheel. Don't risk my family's life. You're right. I'm talking about when you do drink. I'm talking about in the future. I'm not talking about on probation. You understand probation. I'm talking about in the future. This is only a year. You can successfully complete this. I'm talking about in the future when you're off probation. You gotta drink responsibly, right? Otherwise, you kill somebody, intoxication manslaughter, 2nd-degree felony, 20 years in prison, and your life is gone. I promise you, your life will be gone. Won't be able to get a job, disgrace yourself, disgrace your family name. I want to show you the worst part right now so that you understand that when you go sit down to talk with your probation officer and you feel like they're being hard on you, or they're being difficult, I want you to think back to this conversation that we're having here today. Okay? You understand? All right, Mr. Evans, hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted. After that, I want you to go to the probation office. You'll join them over here. Needs to be fingerprinted and then he'll go to probation. Christopher Hunley. All right, this is cause number CR 2344, State versus Christopher Lamar Hunley. Mr. Hunley, will you raise your right hand, sir? Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. You are Christopher Lamar Hunley, is that right? And Mr. Hunley, are you a United States citizen? Do you read, write, and speak English? Ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation? Feel like you've had enough time to discuss your case with him, have all your questions answered? Anything about the case and the paperwork that you've signed here today that you do not understand? I see here that you have been charged by indictment with possession of controlled substance in penalty group 2, less than 1 gram, which is a state jail felony. However, I see that the plea agreement is for you to be prosecuted under section 1244A of the penal code, which means that you would be convicted as a felon, but punished as a misdemeanor. And the recommendation from the state is that you plead guilty and that your punishment is 30 days confinement in the Van Zandt County Jail. You'd get credit for 2 days. You would have 28 days to serve. You'd also have a $4,000 fine, $180 restitution, and the state would be dismissing a possession of marijuana, 5 pounds to 50 pounds. In addition, you would pay court costs of $290, restitution of $180, and a $35 reimbursement fee. Is that the plea agreement that you've worked out with your attorney in the state? And that's what you want the court to approve? Mr. White, do you believe Mr. Hunley to be competent?
Your Honor, I believe Mr. Hunley is competent. They understand, see the opinion, they also execute the way that the court.
Thank you, Mr. White. Mr. Hunley, how do you plead to the charge of possession of controlled substance in penalty group 2, less than 1 gram? And are you pleading guilty because you are guilty of committing that offense? Has anyone threatened or forced or pressured you to plead guilty? All right, court accepts the defendant's plea of guilt. Mr. White, any objection to states 1? All right, states 1 is admitted in evidence, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state, from the defense?
No.
Lab report. Mr. White. Can you fill that out, the plea agreement right there? The options. You want this? There you go. You want that? Take that. Criminal is yes. States Exhibit 2, I've shown this to Mr. White. Any objection to States Exhibit 2, Mr. White, the lab report? All right, States Exhibit 2 is admitted into evidence. All right, Mr. Hunley, the court's reviewed the evidence. I find that there is sufficient evidence to convict you. Court will follow the plea agreement that you reached with the state. Court convicts you of possession of controlled substance in penalty group 2, less than 1 gram. The court assesses your punishment under section 1244A of the Texas Penal Code at 30 days confinement in the Van Zandt County Jail. The court will give you credit for 2 days for time that you have spent in jail towards your sentence. Court orders you to pay a $4,000 fine, $180 restitution, $290 court cost, $35 reimbursement fees. Court dismisses under section 1245 DA 2020-67 a possession of marijuana 5 pounds to 50 pounds. Mr. Hunley, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted, and then you'll be taken into custody at this time. Whenever you are released from custody, I need you to report back to the courthouse and meet with the court collection compliance officer, Ms. Bonnie LaPrade. She's on the same floor at that end, and meet with her so you can make arrangements to pay off your fines and fees. If you don't do that, what's going to happen is a warrant's going to issue for your arrest, and you're going to go back to jail. And it's not good for us, and it's not good for you. And as long as you're making an effort to pay it off, then we'll work with you. Okay. All right. If you'll come on and step forward to be fingerprinted. Thank you, Mr. White. Okay, they did do this waiver. Okay. Do you want me to go ahead and sign? Oh, it's in the file. I can just make it sign. Sticky note on here, so I don't look at it. Good. For the record, CR 21-141, State versus Caleb Reed Richardson. Set for arraignment today. Mr. Manning did file a waiver of arraignment. Court has reviewed that, approves it, and is setting pretrial for September 14th. All right, Mr. Knoll, who are you ready on? Is he gonna be a plea today?
Today was the day he was the interim plea that we put on a trial block. The final plea offer was 16.
Well, hang on, let's go ahead and bring him up. Mr. Couch, this is CR 2153. If you'll come to the center podium. Now, my docket says that he was at the plea today, not, usually it'd be separate docket call if he was gonna plea or announce plea or trial, but did I write that down wrong?
I don't think the court wrote it down wrong. I think Mr. Couch was quite candid with the court is making a serious error. As indicted in cases of 220, he is subject to a Brooks notice, making it a 25 for life. The plea offer that he is passing up today is 6 years probated for 3. Obviously, that's his call.
And state if Mr. Couch goes to trial, will there be an enhancement?
Yes, sir.
And what would the enhanced penalty range be? Minimum 25? All right, Mr. Couch, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. So, Mr. Couch, you understand that today's the deadline for you to either announce to the court that you want to enter into a plea agreement or that you want a trial. Now, you've been in court while Mr. Knoll has indicated what the offer was from the state, which is on a 3rd-degree felony offense of tampering or fabricating with physical evidence.
It is enhanced, so it's actually 220 years.
2 to 20. So it's a 3rd-degree enhanced.
Yes, sir.
So it's tampering or fabricating with physical evidence that's been enhanced, that if the state proves the enhancement allegations on a 2nd degree, then it would be 2 to 20. And if you go to trial, then the state's indicated that they're going to allege all of your prior enhancements. And if they prove those, all your prior convictions, if they prove those, that and you're subsequently found guilty by a jury, then your minimum sentence would be no less than 25 years in prison and no more than 99 years or life. You understand that the offer from the state is that you would be placed on probation today, and that the sentence would be, their recommendation would be 6 years in TDC, with that being suspended and you being placed on 3 years community supervision. And you understand that if you reject that today and you move forward to trial, that the court's not going to allow you at trial to change your mind and say, now I want to enter into a plea agreement. I doubt the state's even going to offer you a probation offer after this. Even if they did, the court's not going to allow you to accept it. You understand that telling the court today that you want a jury trial means that this offer goes away and we move forward with jury trial, and you take the circumstances as you find them. If you're found guilty and they prove your enhancements, then the jury would be instructed to return a sentence somewhere between 25 years to life. You understand all of that?
Yes, sir. I was understanding that, I would get one more option.
You're asking for another offer?
But I was under the impression that was going to happen. Right?
If I may, actually, he did, because the prior plea offer was 10 probation for 3. Today, it's 6 probation. The concept that you just keep getting better and better offer, I don't know how that. Sometimes, but he actually did today.
So understanding that, Mr. Couch, what do you want to do today? Do you want to accept the plea agreement or do you want to reject it?
Judge, my attorney is very hard to speak with. And I think that get through, it's gonna all for communication well.
What is it that you're trying to communicate to him that you can't?
None at all, I'm very rude. And yeah, I was doing it in my best interest.
But what is it that you're trying to communicate to him that you haven't been able to communicate? What is it that you're trying to communicate to him? I hear him communicating to you today.
The whole case. That he finally got to my office to review video. And the statements and everything else. The concept of tampering with evidence, as it's been explained to him. The example I always give, it's actually a true case. Man walking down the street with a cigarette behind his ear. And maybe it's a regular tobacco cigarette. And the officer walks up and says, "Is that a marijuana cigarette behind your ear?" And they eat it. Even if it was tobacco, it's tampering with evidence. So all of that has been explained. He's seen the video. There is nothing positive in the video. I have a witness statement which the state has been given. And they are more than happy to proceed to trial after that witness statement, which they have some credibility issues with that witness statement. I don't know what else I would do. It doesn't matter, sir. Tampering with evidence. Evidence can be evidence of innocence. It's the tampering that is the charge. Lost this.
Mr. Couch, what do you want to do? Do you want to take the state's offer or do you want to reject it? I'll tell you what, I'm gonna do this. Since you were late, I'm gonna drug test you today. And while you're waiting for that, I want you to think about it. Okay? So come over here and have a seat in the jury box. Mr. Waddell, I'd like to administer your analysis test to Mr. Couch. Just have a seat right over here in this jury box. It's up there in the top corner, that's fine. Thank you, Mr. Waddell. Mr. Crane, are you ready?
As of today, I have Miss Thompson that was set today. She's set for a range. She's in the jury box based on a 19-month-old revocation that apparently has been sitting out there tonight. So that's why she was arrested today, is on revocation. But today she is here on a burglary of a building case. She has been given copies of the document. I think she's ready.
Are you ready for me to call the case?
I am.
All right, Miss Thompson, if you'll come on around. I'll tell you what, you don't have to go out there. Just come right here to this area right here next to Mr. Noel. This one. Right there by that podium. That way I can get you on camera. There you go. All right, this is cause number CR 21193, State versus Audrey Jean Thompson. And this is strictly on the arraignment for the burglary of a building. Have you been provided a copy of the indictment?
That I had, she has also, I believe her name is spelled correctly in the document. I think she understands the charge. Straight in from her. Fairly simple charge. You know, not guilty on the charge at this time. And she says that here we go.
Ms. Thompson, do you understand what burglary of a building is?
Yes, sir.
Have you read the indictment?
No, sir.
Do you want a chance to read that with
Yes,
Mr.
I
Noel?
do. And I don't fully understand the indictment, and I am not moving along with my attorney, just like the last guy was not moving along with me, or I am not moving along with him, and I am asking if you work with somebody else, please, because he's been very rude to me, and he's put it in my face, almost spit on me. I said, "Come out right now." Can I please get an attorney here and all on the same page? Asking the nice way possible.
If I could.
Well, hang on before we do that. So I showed that you were to be back here today to hire your own attorney. You were in here once before. Let me ask some questions. Did you go out and try to hire your own attorney? Did you speak with other attorneys?
Yes, it is, and he's on vacation as well.
And who is that?
It's Syrian.
Okay, and how come did you speak with any other attorneys? Why not?
He said he would represent me, but he's on vacation.
Or we can do anything, this is on vacation.
Was he on vacation the last time we were in court too?
No.
What did you tell me the reason that he wasn't here last time? You told me the same thing.
Well, I didn't know that I was supposed to do an hour. I didn't know what the first court date was gonna be about. When I-
But today you requested the court to appoint you an attorney.
Because I don't have one for vacation, so I mean, I represent myself and then
Well, the court found you to be indigent and has appointed Mr. Knoll to represent you. So the way it works is either you hire your own attorney or you get the next attorney who's up on the list, and Mr. Knoll's the next one up on the list. So go ahead, Mr. Knoll.
The first question I asked after I saw the state jail felon offense was, do you have any priors? Her answer was, no, yes. Right up, excuse me.
In just a minute, I'll give it to you.
That bothers me. Then I wanted to be able to talk to her, and she says that that's her sister who kept following her around. I do not waive attorney-client privilege. I don't care who the other person is. Then she needed to go outside. She went outside, got on the cell phone, doesn't matter why.
Let him finish. I'm gonna give you a chance to
So I
talk.
walked outside, she hung up the phone and came back in. She has had a copy of the indictment for at least a half hour, and she has not read it. If she wants me to read it to her, sometimes there are problems with people that don't read well. I don't have that problem either, because I've been down that road reading stacks of paper and somebody told me after back in the day. Probably 30 years ago, we've done this a while. Sometimes people have trouble understanding words, reading, who knows, it's lexic of people's town. So, please, if you want to hire everybody to do something, maybe they have more than 37 years of doing this tonight. But I do not like wasting my time.
So let me ask you too. You've asked for a court-appointed attorney. Mr. Knoll has agreed to be a court-appointed attorney. You two are appointed to each other at this time. If we're not going to be able to get past this, I've already got concerns that if we're at the very first meeting and both of you seem to be very frustrated with the other, you don't have to like each other.
I'm not sure, like, these words,
You just have to be able to work together.
I'm trying really hard.
So I need to hear, so you're telling me you're not gonna be able to work with him?
I don't think so.
Mr. Knoll, do you feel like you're not?
Is this you pointing this paper in my face? Is this you? I don't even know what it is. I don't even know what that says. So
Did you read it?
I was trying to read it. It acted like I don't know what it was. Like, I don't know.
That is not her
I
preferred.
would be saying anything. I get so disrespected by him. Sir. Thank you.
I'm happy you won.
All right, this is what I'm gonna do. I'm gonna allow Mr. Knoll to be off the case. I'm going to reset you for arraignment. I'm not gonna appoint you another attorney. I'm gonna put you in custody on your warrant and we'll reset you, and I want you to try to hire this attorney that's on vacation or wherever he's at and have him come to court next time. And the next time you come to court, if you don't have him, we'll think about whether or not you get another court-appointed attorney.
Sir, it says on my paperwork that I don't have a bond. Is that whether I can get a bond? Like, I don't, so this paperwork is wrong.
I don't know. That's the warrant. I'm not here on this case today. You're in custody on another case, another warrant that I don't have before me today, so I don't know.
Okay.
But if it's a motion to revoke, if you're on probation and you were convicted and it's a motion to revoke, then bail does not attach to motions to revoke.
So there's nothing.
As far as what?
It's bonding out.
Can't bond out,
No bond.
get a no bond. Do you want me to give you some time to see if you and Mr. Knoll can work it out? And then maybe he can talk to the state to see if there's a way to work out your, don't have to like each other, but you got to respect each other and be able to have a clear line of communication. And if y'all can't do that, that's fine. Sometimes personalities clash and we can make other arrangements, but I think it's probably in your best interest now to at least hear him out and Mr. Knoll, just understand where she's at and what she's going through today and see if y'all can't clear the air and come back and let me know. So I'll recall your case. So, all right. So I'll recall the case in just a few minutes and give you all a chance to talk a little bit more. And bailiff, I'm going to allow Mr. Knoll to take Ms. Thompson. If you want to go to the back of the courtroom, you want to do that? All right. So I'm just going to allow them to go to the back of the courtroom and have a seat so they have a little more privacy. And then y'all come back up here when y'all ready. And whatever it is, if it's, you can't work together, great. If you can, great. If there's an announcement, great. Just let me know either way. Okay. I don't know. I haven't seen them. If you want to go check with them, you can. Yeah. Yes. All right, Mr. Crane, are you ready?
Yes, sir, Coach.
Yes. Thanks, sir. Ms. Olds. Woodwhite. Lab report. All right, Ms. Olds, if you'll raise your right hand, I'm going to place you under oath. Ms. Olds, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, you are Ashley Autumn Olds, is that right? Ms. Olds, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Adrian Crane. Are you pleased with his representation of you? You feel like you've had enough time to discuss the case with him and have all your questions answered? Anything about the paperwork that you've read and signed today that you do not understand? Mr. Crane, do you believe Ms. Olds to be competent today?
Yes, sir.
And you've explained to her her legal and constitutional rights?
Yes, sir.
I see here, Ms. Olds, that you're charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 2 in an amount less than 1 gram. That is a state jail felony offense and does carry a range of punishment if convicted and sentenced to not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division. Do you understand that? Also could include a fine up to $10,000. I see that the plea agreement that you want to enter into with the state is that you plead guilty to that charge in exchange for the state's recommendation that your punishment is assessed at 2 years in that state jail division, with that sentence being suspended and you being placed on community supervision for 3 years with a $1,000 fine, $180 restitution, $290 court cost, $35 reimbursement fee. And the state would be asking the court to dismiss and take into consideration 2 DWI cases And as a part of your probation, you would be placed on intensive supervision. Is that your understanding of the plea agreement? No, sir. It's a $1,000 fine. So if it were a $10,000 fine, I would consider it, but I don't probate the fines. So Ms. Olds, understanding the charge and the plea agreement and the range of punishment, how do you plead to that offense? And are you pleading guilty because you are guilty? Has anyone threatened, forced, or persuaded you to plead guilty today? All right, the court will accept the defendant's plea of guilt. Mr. Crane, any objection to states one, the stipulation of evidence?
No, sir.
All right, states one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No, sir.
All right, based on the court's review of the evidence, I do find sufficient evidence to convict Ms. Olds of this offense. Court will follow the plea agreement in this case. Court convicts Ms. Olds of the state jail felony offense of possession of controlled substance in penalty group 2, less than 1 gram. Assesses her punishment at 2 years confinement in the state jail division of TDC. Court will suspend that sentence and place her on community supervision for 3 years. Order her to pay a $1,000 fine, $180 restitution, $290 court cost, $35 reimbursement fee. The court does dismiss under section 1245, DA 2020-671, DWI, and DA 2020-1219, DWI. As a condition of community supervision, the court places Ms. Olds on intensive supervision. Ms. Olds, you have been on probation before, haven't you? I think I put you on probation when I was DA, didn't I? So I don't need to tell you the do's and don'ts, right? Because you know better. So if we have a drug problem, now's the time to get that fixed. they're not gonna fix it in state jail when you're just serving out a sentence. They can help you work on it. There's no fixing a drug addiction. There's no fixing it. There's getting help for it. And we can do that through safety, but not while we're just sitting out a 2-year sentence. You have children, right? I know one of your daughters. How many kids do you have? You have 3? I know Justice. Sweet girl. Yeah, several times. Yeah, I know Justice. Sweet girl. Love her. She deserves better. She does. Are you gonna give her better? I mean, she deserves it. And I'm certain your other 2 kids do as well. I don't know them, but I know Justice. I may have. So one of the benefits and also disadvantages of living in a small town, right? So I've got high expectations for you, and I'll be seeing you around because I'm going to be involved in your kids' lives because they're in school with my kids. I'm going to coach them, and I'm going to help raise them in the community and do what I feel like I need to do and I want to do. All right. So I would love to see you be successful, not only for your sake, but also for your daughters. Okay. All right. So Ms. Olds, I'm gonna have you step forward to be fingerprinted and then report over here to Ms. Burns and they'll give you additional information. Thanks, sir. Thank you, Mr. Crane.
Thank you, sir, very much. Appreciate it.
You're very welcome. Ms. Beasley, are you back for me? Or are you back for the ADAs?
Actually, both good.
Okay. Is it someone this afternoon?
Thursday, I think. So.
Thursday, okay. And I haven't forgotten your request to go in chambers, but I figured that may be resolved. I figured as much. Semi-resolved. I just. All right, we're back on the record, CR 21-193, State versus Audrey Jean Thompson. All right, y'all had a chance to meet and discuss. Are we in a different spot than we were before? Mr. Knoll, what do you think?
I guess my spot is I explained, I really not keep her name spelled correctly. She doesn't understand the chart. Giving her examples of how someone could be charged with this time charged presently before the court. I was given, and she has been given a copy of the motion for the vote. Obviously, it's not. before the court. MRI, right. And then, at any rate, I've asked, well, let's go back. Obviously, the old case was actually in which is a correct case, is the basis of the motion. She has a copy of that, given that to her. I asked the state if they would consider entertaining some sort of bond. Explain to her what has no obligation. Said any kind of bond at all, period. The state would entertain the bond, say, that. The state said they would not. Just asking the court to entertain the bond, said if they pass on the law. Or, I mean, obviously, the court can do anything, but it's the court's court. But she lived in Minneola. In reference to the later right example that a judge told me more than an hour before I should have been with her. Never mind. It's 30 minutes away. She should be out. At the court, state.
Ms. Thompson, do you want Mr. Knoll to continue to be your attorney, or you still want to stand on hiring your attorney or requesting a new attorney? Do you feel like y'all are able to talk now?
Thanks.
All right, Ms. Thompson, I don't want you to give me any more information than just what I asked you, okay? Did you successfully complete safety? All right, so I'm reviewing the CR 15 case and I see a note that the motion to revoke warrant did not issue in 2019 at all. So it was only issued today, correct?
It's not a her portion.
I haven't seen that stuff. I know it's-
She did, yeah, she was placed on deferred and then she was adjudicated 5-5. And then the newest motion to adjudicate states unsuccessful discharge from the Salvation Army Substance Abuse Program, which is probably the halfway house or the next step after safe release from safety.
that would be my understanding. How many months, 6 months, whatever. Okay, what's- what I would consider. There's a minor issue. regarding it's minor, it might not be minor. Didn't involve drugs or anything.
Well, I'm sure there's an amended one coming down the pipe with the Burkett building charge. Feel pretty confident about that, but. All right, so this is what I'm gonna do for you, Ms. Thompson. You'll pass the drug test today if I give it to you? All right, I'll give you the drug test. You pass that, then I'll give you a bond on this motion to revoke. Okay? No, I'm not gonna do a PR. If she didn't have if she were here standing before me just on a new warrant that issued today because of a 19-month overlap or whatever, then I would, but because she's here on a new charge, a new allegation, and that she's posted bond on, I'm not, but I'm not gonna set it high either. So, but let's wait and see what the drug test says. All right? All right, so go over with Ms. Burns and do you need to have her uncuffed so she can do her test? I didn't know how talented she might be. So. Yes. All right, we're back on the record, CR 2153, State versus Joseph Couch. Mr. Couch, what's the deal? I'm giving you over an hour to give a test.
I've been trying to talk to you. I wish I could.
Have you drank water?
Sir, I think that's just a problem. The problem I have is my stomach.
Well, unfortunately, Mr. Couch, I've given you ample time to give a test. So at this point, it's going to be considered a refusal.
I've been trying.
I understand, but I can't sit here and wait all day. If you would have gotten here earlier, we would have had more time, but you were late to court, so you didn't give us much time to work. Well, I understand, but you weren't here at 9 o'clock. So we had 3 hours to try to figure this out. Now we got a lot less than that. So unfortunately, Mr. Couch, I'm going to consider your not giving a test, not giving a sample. Listen, I understand. I've got no choice right now. I'm gonna consider you're not giving a sample a refusal, and I'm gonna find your bond insufficient. I'm gonna place you back in custody.
I've really been trying to keep it.
I understand. I've given you an hour and a half.
Every time I start pushing, I feel like I'm in the all of myself. It's actually like water going back out the other end.
Well, I don't think I've ever had to urinate and had to push. That's not how urination works. So
I've been trying to honestly. I really have.
so what do you propose I do?
Do you have a report to call
When?
today?
For what?
To take a drug test?
So that you can leave and drink a lot of water and dilute your sample
No, sir.
to get someone else's urine to provide it,
No, sir.
to not show up?
No, sir. I wish it would.
What do you think, Officer Waddell?
Your Honor, I believe we sat in time next week in amount of water.
Much water as possible. I really have.
He has drank a lot of water.
I've been a lot of trying to be. I've been so much, I wish. I don't know when I'll be here.
My docket says that Mr. Couch is delinquent on his fees as well. Is that correct? Has he been reporting? Yeah, he was set to plead, but that looks like that's gone away. You got it caught up? He said he paid up last week. Do you know how?
As of this morning,
It was 2 weeks ago when I left I came in to work, like $10 hospital.
as of this morning.
They're saying as of this morning, it's $100.
Yeah, I paid it. We still not.
No, you did. You were delayed $100 this morning.
Unless they had come, I paid it. I usually say that I would pay up.
What about Ms. Thompson? Do we have her? Did you give your sample? All right. We don't have all day, so what I'm gonna do, Mr. Couch, is I'm going to find your bail to be insufficient at this time for failure to test. I will have you pulled. I'll be at the jail this afternoon. I'll have you pulled and we'll do a drug test out there. If you're clean, I'll reinstate your bond and let you go. If you're dirty, you'll stay. So go ahead and have a seat over here. And bailiff, if we'll go ahead and take Mr. Couch into custody. Court has found his bond to be insufficient for refusal to give a test with time requested. Come on up, Mr. Couch, have a seat over here. Yes. Oh, you didn't give me an order. So I'll be out there in about hour and a half. All right. Now, Mr. Knoll, with regards to Mr. Couch's plea, are you on the docket this afternoon at all?
No, but only
Can you zoom in this afternoon? Can you? All right, if you'll do that, I'd like to recall this case this afternoon after I drug test him, and then we'll nail down the issue with the plea, and that way you can go back to your office and you don't have to hang around. Is that fine?
find it, if you test it positive, obviously I would. Anyway.
Of course, of course. So we'll recall your case this afternoon. With Mr. Knoll. Mr. Knoll, he wants to talk with you before he goes. You wanna do that now?
I was the last minute conversation. I will.
And so, Ms. Thompson, I'm gonna do the same thing for you. I'm gonna go ahead and we're gonna take you on your warrant, and then we'll do a drug test this afternoon. All right, so maybe an uncomfortable hour and a half, but I mean, go to the restroom, but just know that if you want me to give you a bond, then I'll need the sample this afternoon, and we'll pull you from the jail and get that done. Okay, that way we're not holding up the staff here. And Mr. Knoll, so we need to set, okay, let's go on the record here. This is CR 21-193, State versus Audrey Thompson. Ms. Thompson, you can stay there. Court's going to find that Ms. Thompson has waived the formal requirements of arraignment. Her name is spelled correctly in the indictment, and based on Mr. Knoll's statement, she does understand what she's been charged with. The court will set Ms. Thompson for pretrial on, you available on August 24th? Remind me your schedule. August 24th for pretrial. And the court will take up her issue of bail this afternoon. Yes, what's that number? Do you know that number off the top of your head? Yeah, I've got it. CR 15-506. Yes, we'll set CR 15-506 on the same time. All right, and then we'll zoom in for Mr. Couch this afternoon. No, if I'll have Ms. Thompson tested, and if she's clean, then I'll set her a bond on the MTR case. And if she's not, then I won't. So won't need to pull her, but Mr. Couch, we need to discuss the plea. Thank you. All right, court's going to stand in recess until 1:30.